Good evening. This is John Milburn for Laws 11059 Introduction, Statutory Interpretation. This is week 3 of Term 2 and, of Term 3, 2018. Now, before we started, a question arrived on the chat line. Thank you, Nigel, for this question. It's to do with the assessment piece number 1, and I was going to raise that with you tonight as well. So, and have a look at some assessments. So before we deal with the specific question, what I might do is share the screen and bring up the assessment number 1, that is your task for the first assessment. Bear with me while I go through that process. Sorry, just finding it is not as easy as I thought. My apologies. Can you tell me if you're now looking at assessment number 1 for term 3? Great. And just to confirm, the assessment is due 13 December, so it's not far away. 20% of which is 20 marks, 2 questions, and the second question relates to a case. The first one is really very simple, a simple research task, so you shouldn't find that particularly difficult. The second relates to Project Blue Sky, a seminal case, and Nigel, your question related to the CLR versus the HCA citation. Is that correct?
Yes.
Okay. So I've given you what's called the authorised citation, but you will find the content in relation to Project Blue Sky in multiple sources. One other source is the HCA reference. I haven't provided that to you there, but you can use that just as easily as you can the CLR reference. The CLR is what we call the authorised report, and generally speaking, the content in the authorised report is very close to, if not identical to, information contained in other reports of that case. But if you went looking in different platforms, you'd find that different references or different versions of that same case appear, but with a different citation. So does that answer your question well enough, Nigel? Okay, you had the mute on there, but I think you were saying yes, but just down the bottom left-hand side. Yeah, thank you, Nigel.
Sorry, so in essence, you've already given us the answer to question 1.
Oh, yes, I have. So that makes it very easy. So the correct case name and citation, but what you can do is just add in an alternative if you wish. Correct. It's a very simple task at the start. Right, so thank you for that. Now, did anyone have any difficulty in any of the content for the first assessment piece? We know when it's due, we know how many words, we know what the tolerances are. You understand that I expect you to use the Australian Guide to Legal Citations, which in short is footnote referencing. If you have any questions about the footnote referencing, have a look at the AGLC Quick Reference Guide, and you'll find that on the landing page in Moodle. So we've got a clear idea of what to do. Proofread your material, make sure it's presented in a professional manner. There is no prescribed form, there's no template, if you like, for use. So adopt something that you like. You don't have to use a cover sheet. Many people do. I tend to use cover sheets quite often. I think it makes for a professional presentation. Some people use, if you can find the official CQU cover sheet, it's okay. It's a little boring to my eye. So you can be flexible in that regard. But as a general rule, when you're preparing something for legal matters, whilst it can be a little different and a little creative, it still generally needs to be reasonably reserved, if I can use that term. So don't make it too flashy. Bit of a balance there. All right. Any questions then about the assessment number 1? Really a very simple assessment, just to get you warmed up. Let's have a look at assessment number 2. I released that this week. Before I share the screen, has everyone had a look at the second assessment? No, not yet? All right. I urge you to do that now in the spirit of looking ahead and working backwards. It's always a good idea to make something of a start. Even if you're working on another project, try to make a start on this project and other projects that are a little down the track. There's a few reasons for that. The first is that if you read the material that you're to answer, you can start thinking about it. You're aware of it. Even if it's not the main thing on your mind, it's still there in the background. So that as you're reading other material, you may come across something that you think is useful for the second assessment or for another unit. You might say, great, well, I'll catalogue that, but you've got to have somewhere that you can start to use as a repository for this information. And of course, you've got to know what the question is. It's always a good idea to set up your template at an early stage so that you can add material in progressively. And the idea is that by adding material progressively, as you come across it, before you know it, you've half written your assessment piece. So it becomes far less daunting, particularly if you find yourself under pressure a day or two out from the due date. So in this instance, assessment number 2 is, again, a 2-part question. Once again, it's worth 20 marks, 2,000 words, so very similar to the first assessment. It's due on Thursday, the 10th of January, 2019. Most of my assessment work is due on a Thursday. The cutoff is the Saturday week, 9 days later. What you need to do in this instance is, in part 1, create a document that you will find useful when you're required to solve a statutory interpretation problem. Essentially, a toolkit, but something that works for you. What might work for me may not be to your eye or work for you. So the whole idea of undertaking this unit is that you can interpret statutes in the way that the law requires. But there's no one template. There's no one way of doing that. So develop your own system, develop your own document that will help you in that regard. And the second is for you to use that document to solve a statutory interpretation based on the material that you've already read. I'm going to pan down. I hope that you can continue to see what I'm doing as I pan down. And I flesh out part 1. The starting point, I think, is for you to go to Michelle Sanson and read chapters 1 to 8. Now, you might say that's an awful lot of reading, but as always, I encourage you to do a quick overview read first up, not a detailed reading of the material, but even if you're reading the headings and a few other parts underneath, to get a feel for it, to get an idea of what's there, and then go back and read in more detail. Do have a look at the rules and methodology diagram in chapter 14. Now, as a quick guide to this diagram, if you look at the back, the inside sleeve of the back cover, you'll see a reproduction of the diagram, which is from part 3, from page 345. So you'll see the flow chart. Now, this is, if you like, Michelle Sanson's approach to interpretation of legislation. You may adopt it or vary it, or you may come up with your own approach. But what I'm going to do is, so that this is personalised to you to some degree, set a rule, and that is that in preparing your flowchart, your toolkit, you need to have a logical 5-step process that you can use to explain your individual approach to statutory interpretation as if you were doing so to other students or legal practitioners. The real intent is that you use this as a practical tool for yourself not just in this unit, but every unit of law that you study and every part of legal practice in which you engage. The idea is this is your document to build upon into the future. I'm just asking you to prepare the foundation. And I do hope that makes sense. Once you've completed your toolkit, for want of a better term, you have an opportunity to consider how to use that toolkit in a scenario. So here we have a situation where Mary works for No Delay Enterprises, an import-export business, and Mary is being prosecuted, potentially unfairly, in relation to a claim for money as a result of some work undertaken by officers. So your task, based purely on statutory interpretation grounds, considering purpose, intention, and other interpretive techniques, is to advise Mary as to her prospects of defending the prosecution made or threatened to be made against her under the material that I've provided. So obviously it's not the real legislation that I've provided there. All right, any questions then about that second assessment? So do you get a feel for this? You get an idea of why I'm raising it now. I know you're busy, but I want you to set out your overall design. You can change it and be aware of what's there so that as you read something, you can start to incorporate it into one of these 5 steps. And it might be that in your toolkit, you include links, hyperlinks to cases, statutes, articles, something that works for you. You might use flowcharts, lists, diagrams, again, whatever works for you but it's got to be a practical application. So any questions then about the second assessment piece? And that's due, just as a reminder, on the 10th of January 2019. All good? Let's look a little further ahead. And whilst you do not yet have access to the take-home paper, I have, I believe, uploaded the take-home paper as it appeared last year. I'm going to share the screen, go through it with you so that you've got an idea of what you might expect. So has anyone read has anyone been through the take-home paper from last year? On Moodle? No. All right, so in this instance, there was 2 hours to complete the task only. So this paper was tough. People had 2 hours only. Previously, this year you have more. You have 29 hours, I think. There were 2 questions on the paper, and the task required the students to analyse a case, Maxwell and Murphy, and to also consider Jaeger and the Crown, extracts directly from your textbook. So if you don't have the textbook, a question like this would make it difficult. So I'd given fair warning last year to the class about that. The second question related to hypothetical facts. And you'll find that with most of the questions I write, or at least in part, there is some application. So here we had 50 marks, so half the marks for the whole unit in this one question, question 2. The question last year was that you are engaged by the state of Queensland who is considering prosecuting someone, a director of a company, for industrial manslaughter. The victim was an employee of a company, and that company was a construction company. The investigations that you had to undertake related to considering the Work Health and Safety Act 2011, and the task was to answer a number of questions. I would like you to look at that paper now so that you know what it is that I expect you to be able to do in terms of research so that you can answer a statutory interpretation problem. But I will go through it now because it provides something of a template, and I think that it's useful to look at this because it gives you an idea of what I think is relevant that you can use in your second assessment, your toolkit. The first thing is jurisdiction. If you're interpreting a statute, you want to know that it applies in the current factual circumstances, and you have to support your answer. So if you're dealing with a case of industrial manslaughter, it's highly unlikely that the Powers of Attorney Act will be the act that has jurisdiction over the factual circumstance, if you understand what I mean. The second is, you then need to consider whether the act is in force, because acts come and go. Acts are introduced, they're repealed, they're replaced, or they're amended. And you need to be acutely aware that in dealing with a factual scenario, you deal with the legislation as it was at that time. So, for example, in a criminal matter, if you're dealing with an alleged incident that occurred in, say, 2003, then you need to consider the legislation that applied in 2003. You may have some recourse to considering the legislation as it appears now, but that's not the primary role. So in statutory interpretation, you need to identify whether the legislation was in force. If so, to what extent and what was the version? You're not going to be able to answer the question if you can't find the historical versions of legislation. So I'm working on an assumption here that by now you know where to find legislation. During this week, you need to find out how to access the historical versions of that legislation. I suspect that you'll need to do that again as part of your take-home exam. So the first two parts, dealing with jurisdiction and whether the legislation is in force, might be part of what I've described there as the identification phase, where you're considering the currency and jurisdiction of the legislation. You can't just assume that the legislation does confer jurisdiction in relation to the facts and that it was in force at the time. You need to research that and be able to say, yes, it has jurisdiction and it was in force for these reasons. Once you've proceeded through the identification phase, go to the operative provisions. So in practice, you need to use your legal research skills to locate relevant provisions. So in this example, and bear in mind the students only had 2 hours for this, they had to identify the subsection or subsections they believe prosecutors might rely upon to charge the individual with an offence. Identify the subsections that you believe the prosecutors may rely upon to charge the company with an offence. So they're the operative provisions. Then you move on to what's called the exploration phase. So when interpreting legislation, consider statutory interpretation principles, consider the ordinary meaning of the words, but also consider the broader context. Explore the context and purpose by considering extrinsic materials and extrinsic materials. Now, you won't get too far if you don't know what I mean by, for example, the ordinary meaning of words, or the word context or the word purpose. Or if you don't know how to access intrinsic materials, or you don't know what they are. Likewise, if you don't know how to access extrinsic materials or what they are. You might recall, I think, in week 1, I said, I'd really like you to have your own dictionary in relation to what these terms that are recurring do mean as far as you're concerned. And I probably said it will be useful as part of your toolkit anyway. So as part of the exploration phase, the requirement was to determine what was the purpose of sections 34C and D of the Act, support that by reference to statutory interpretation principles, and if prosecuted, could Tracy claim the defence of accident? Again, that becomes more apparent once you look at the legislation. Then the next phase is application. Here's where you can find your comments to matters relating to statutory interpretation, certain things you don't consider. So you can see in the application phase, You're required to identify what prosecutors need to prove, what they need to prove against the individual or the company. Then who will prosecute? Sometimes overlooked. In criminal proceedings, not every government agency has the ability to prosecute, and it's not always police. It may be that the legislation provides for a different prosecutorial regime and not just the Queensland Police Service or the Australian Federal Police. Is the prosecutor subject to prosecutorial guidelines, and where can they be found? So you need to look broadly to answer some of these questions. And then finally, some further questions. How would your answers change, if at all, depending on the date that the industrial accident occurred? And I've given scenarios there of 2018, 2016, 2012. So that gives you an idea of what it is that I expect you'll be able to achieve by the end of this unit. It's not meant to scare you, but it serves a dual purpose. The first is that it gives you an idea of the sort of thing that you might have in your take-home paper. By looking at that paper, you also have some idea of the structure that you can follow as part of statutory interpretation principles. And finally, it gives you an opportunity to do a test, so that if you now want to have a go at answering that question, please do so. And if you don't know the answers, then that's fine. We wouldn't expect you to know them at this stage, but at least you'll be more acutely aware of what it is that you need to look for as part of your reading. So you need to carefully consider how to apply these principles in practice. I'm sorry, I'm talking a lot, but has that made sense? Do you understand what I'm trying to achieve here? And it's all part of looking ahead and working back from there. All right. Now, some comments. Could we get you to briefly read our attempts with comments? That's on Moodle, Shona. Is that what you meant? Yes, says Nicole. I can do that. What I like to do is come in a little later. So I'll come in with some comments down the track, but the idea is that you also engage with each other. And what I have noticed, if I come in with a comment, that seems to end the discussion, which is not my intent. So please feel free to engage in an ongoing discussion and encourage and support each other through that process. Now, did everyone find the explanatory notes provisions as part of the Queensland Government Handbook? Did we all find that? As I recall, that was some homework that I set for you last time. All good? So I'm going to share the screen and look at 6.1, dealing with explanatory notes at this stage. This is the Queensland Legislation Handbook, is a very valuable resource. And what I've provided there, explanatory notes, is simply a sample of what it is that you can access in this regard. Just broadening the page a bit, you can see on the left-hand side that subordinate legislation is in 17 subparts. So subordinate legislation is 6.1, and you'll see that 6.11 deals with explanatory notes. And then you can drill across to the right to get some further information. But if we look at if we expand out on the left-hand side of the page, and I hope that it's coming through clearly enough on your screen, please feel free to look up the legislation handbook in Queensland for yourself as we're proceeding through this. But on the after the introduction, we have context of legislation. Some valuable information, and you can refer to this or access this as part of your toolkit or in applying the material before you. So it's very authoritative, and I would ask you to look carefully at that. Read it in conjunction with a textbook, please. I'll stop the share. Now, just to get you working on your keyboards, can I please have you, and I think I did this last week, so it's a quick refresher, give me 3 sources of where you might find a Commonwealth bill. There's probably more. I think there is more than this. I'm sure of it. But just give me 3. I say to you, find the bill, Ostley, yep. That's probably the first place I'd look, to be honest. Westlaw, I think it is, Nigel, yep. Parliamentary website, yes. And one more. Hansard, probably not. Maybe not Hansard. Parliament, federal legislation, there you go. So I would look at, for me, I'd look at Ostley, the Federal Register of Legislation, parliamentary websites. You won't find every explanatory note or memorandum in every instance. In Queensland, similar. Have a look at parliamentary websites and have a look at the Queensland legislation or Ostley. Now, has everyone looked at the Federal Register of Legislation and done a search for acts? You've done that? Can anyone tell me if they've discovered how to find historical versions of legislation? Yes? Very good. I hope you have. So that's excellent. And it's pretty simple. If you're watching this as a recorded session and you're suddenly feeling terrible because you don't know how to find the historical versions of legislation, then please do some research, have a look at the website. You can go through this process of discovering for yourself, or you can ask for some help. Use the Q&A facility, because whilst I might be able to help you, your fellow students might be able to also help you, and I would encourage you to help each other. Use the Q&A rather than send me an email if you would. Finally, if you're really stuck, have a look at some legal research videos. Certainly I've prepared some, and there are others there as well. Now, does everyone know how to find the date of assent of a Commonwealth Act? If I said to you, I'm not going to ask you, don't worry, I'm not going to ask you to share the screen and show me. So it's an honesty provision here. Would you be able to find the date of assent of Commonwealth legislation? Primarily, yes, a few no's. So if you're in that no category, this week, please learn how to do that. And if you find that you're very excited, you've found a way that works for you, because there are different ways to do this, please share it on Q&A and let us all in on the secret. You can incorporate this into your toolkit. You can see why I ask you to start your toolkit now, because every time you find something that is going to be useful for you in terms of a practical step and applying the research that you're undertaking, you need to have it documented. So the toolkit assessment 2 is the repository for this information. So can anyone tell me if they can find the second reading speech, Commonwealth? And if so, where would you find it? If I said to you, please find a second reading speech now, Commonwealth, would you be able to find it? We're getting a few yeses. That's good. Where would you look? Anyone wish to add the extra for the bonus point? I believe you. If you say you can find it, Hansard might be one place to look. You'll also need to do the same thing for second reading speeches in Queensland. Now, in the Commonwealth level, is it an explanatory memorandum or is it an explanatory note? Commonwealth, memorandum or note? What's your vote? We're getting a few answers coming in. Excellent. Everyone who's profited answers correctly said memorandum. Really, they mean the same thing, but in Queensland we call them explanatory notes. Now, who can tell me where to find the object of an act? Where would you find the object of an act? The beginning of the legislation, typically. Yep. So usually it's section 3 or section 5 or something along those lines. You also need to look out for dictionaries. In The New Lawyer, there is a chapter on statutory interpretation. I'm just going to share the screen now. if you have access to the new lawyer, if you're currently doing Introduction to Law or you have previously done Introduction to Law, I found this useful. I'll share it. And you might find that also a useful way of interpreting legislation. So it's along the same lines of what Michelle Sanson has prepared, but much simpler. And you can see that all roads seemingly lead to use the purposive approach and interpret the statutory provision so as to promote the purpose of the statute. That's kind of the key element. And you'll find that that's relevant in terms of Project Blue Sky, amongst other things. All right, so that extract, which was from the original The New Lawyer, we're into the second edition now, was on page 246. If anyone has difficulty in accessing that and they'd like that information, please just ask on Q&A and someone will no doubt share it, or if need be, I'll dig it out and share it. But again, you can see part of what I'm encouraging you to do now is to assist each other and share information. Screenshot it, yes, that'd be great. Did you get that done? I moved on. All right, so that's the sort of flow chart that might be useful. Now, interpreting legislation, chapter 3 of your textbook, Michael Kirby said this, and I'll just read this quote. Statutory interpretation has replaced the analysis of judicial reasons about the common law as the most important task ordinarily performed by Australian lawyers. This was inevitable as the amount of law made by or under legislation increased and the room for the residual common law narrowed. So when I started in 1977, we actually studied much more common law than we now teach at the university level. And the reason is that since 1977, there have been far more pieces of legislation passed than was the case in the prior, well, how many years is that? Is it 40, 30, 40 years since I've been practicing? 41, so thank you. So in the last 41 years since I've been practicing or learning law, many more pieces of legislation than when I started, and so on. So it's become much more important. And if you're answering a question about statutory interpretation, you really need to start, I think, with the contextual approach or the purposive approach, and you'll read all about that in the material in the section, or this chapter rather. So the idea is that you're adopting either or indeed both of those. And you can be a little flexible when you're interpreting legislation. Courts adopt a more contextual approach to interpretation, takes context into consideration. The style is on the way to purposive approach, but not as broad. It's derived from the common law, but the purposive approach interprets a statute where there may or may not be an oversight or error. The oversight or error, when corrected, must support or add to the argument. And there are 3 points to consider when adopting the purposive approach. Explain and provide evidence as to the mischief with which Parliament was dealing. You can't really talk about the purpose of legislation unless you've identified why the legislation has come into existence. And you really can't identify why the legislation has come into existence until you identify the mischief with which Parliament has intended the legislation to overcome. Does that make sense? So firstly, you've got to explain and provide evidence as to the mischief. I'm going to stop there. Can anyone tell me how you might go about finding evidence of the mischief with which Parliament was dealing? Do you make it up? Do you guess? The long title. That's a good place, Gareth, to start. Secondary speech, the second reading speech, Nigel. I agree with that. Anything else? They're really good ones. The object clause, yes. That will give some hint as to why the legislation has come into effect, the mischief. So second reading speeches, long title, the objects clauses, the explanatory memorandum or note. Thank you, Megan. Took a while for that answer to come out. They're the starting points, but you can go much beyond that. You can look at it potentially international treaties or covenants. It may be, for example, that Commonwealth legislation dealing with the environment comes about as a result of a desire to overcome a mischief, and that mischief was manifest through international treaties and obligations. So that might be, you might even go back further. So there are a whole range of places where you might look to determine or provide evidence as to the mischief with which Parliament was dealing. The second thing, because I mentioned this is in the context of the 3 points when using the purposive approach, is this. Number 2, purposive approach. Demonstrate that Parliament has inadvertently overlooked an eventuality that must be dealt with if the purpose of an act is to be achieved. What we're really saying, for the most part with statutory interpretation, is we're trying to interpret legislation within the context of a factual situation. Now, if the legislation precisely dealt with that factual situation, we're not likely to have to apply statutory interpretation principles. We just read it and it's there. But usually it will be a case of something's overlooked, hasn't been explained in full, and that's where you need to go back and look at these things. Number 3 is convince others with a great deal of certainty of the words that Parliament would have or would more likely use to overcome the omission if its attention had been drawn to it. Now, they're the 3 things that you might consider when using the purposive approach. I've adapted those comments from a case, and the case is Birmingham against Corrective Services Commission of New South Wales. That's BERMINGHAM against Corrective Services Commission NSW, 1988, 15 NSWLR 292. Now, do we all know what delegated legislation is, or can we find that information? Just a quick poll. If you had to explain what is meant by delegated legislation and how it comes into existence and the extent that it's binding, would you be able to do that for someone? Yes, 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 mostly. Good, good. If you don't, there's no problem with it. We're only in week 3. But please, by the end of next week, understand what delegated legislation is and how it comes into existence and to what extent it becomes enforceable. All right. So essentially, Parliament simply can't make all the laws. It has to delegate the powers. It delegates those powers to the executive. The executive then make regulations or bylaws or ordinances. That's all part of delegated legislation. It's still legally binding and has full legal effect. It's just that the executive has no inherent power to make any of these laws. Anything it does in terms of creating laws, both through delegated legislation, can only come about as a result of Parliament delegating the power to do so to the executive. And I'm not just talking about executive at a state level, talking about executive at a council or shire level as well. And in fact, much of the delegated legislation that we have in existence comes about at that 3rd level of government, the 3rd tier. All right, so yes, we went through that on Monday in intro, exactly, for those that are doing Introduction to Law. Now, we know that in this subject, you must have a very good understanding of the Acts Interpretation Act Commonwealth, which is 1901, and the Queensland version, which is 1954. Would I take it that everyone has looked at those pieces of legislation? So that's a yes. I won't even ask you to answer that one. Next is, has anyone looked at every heading and subheading to get an overall view of both pieces of legislation? Honesty system here. I'm not saying, have you read the whole lot? I'm not asking if you read every word, but I am asking, have you been through the entire Act in terms of the headings, the subheadings, and got a feel for it? No, you're being very honest. That's good. I like that. A few yeses, but mostly no's. So, do I have to spell it out? I will. This week, if you haven't already done so, please look at both pieces of legislation, go through the entire Act, get a feel for the Act, look at the headings, look at the way the Act is set out, broken down. Good, it's already on the to-do list. I like that, thank you. And make sure that you have a broad understanding of what is contained within the Interpretation Acts. Now, that might be relevant for an assessment piece, because if you have a factual scenario in relation to, let's say, the Work Health and Safety Act, as was the case last year, there may be something included in the factual scenario that is actually not dealt with specifically in that legislation. Now, I'm not going to tell you that if you can't find what you're looking for in that piece of legislation that I may have given to you, I may have said, here's the Act that I need you to look at in the context of these facts. You might go through the Act and say, I just can't find it. You know, there's reference to business days. I can't find any definition of business days in the Work Health and Safety Act. So how am I supposed to work out an answer to this problem? That's where you need to go to the Acts Interpretation Act, which is this catch-all piece of legislation that assists you in interpreting specific things, particularly if you can't find what you're looking for in the specific Act. Does that make sense? So today, earlier, I talked about the jurisdiction of the legislation, which is kind of a misnomer, but I think you understand what I mean. And you then have this overriding application of the Acts Interpretation Acts. And in order to understand and use that, you need to have a little bit of an idea of what's there so that you can keep that in your memory bank and say, hang on, I do remember something about what is meant by a month, because I think I saw something about that in the Acts Interpretation Act, because you've seen it in the headings. You haven't read the section. You don't remember the section, but you know where to look. Does that make sense? Good. Okay. So both pieces of legislation through to a good level, please. The next one is the Statutory Instruments Act. I suspect people haven't looked at that piece of legislation yet. I am going to ask you to do so. This is Queensland, the Statutory Instruments Act 1992. This is what you must keep this in mind in terms of delegated legislation, and I'm going to ask you to look at the long title and get a feel for each of the various sections of that legislation. It's not a long act, but it'll give you an idea of how the Act fits in and how the whole system operates. And it's a key mechanical act in terms of creating regulations and things of that nature. So that's statutory instruments in practice. But here's what I'm going to ask you to do. Using NoteUp in AustLII, you'll see a range of decisions that exemplify the broad nature of what might be regarded as a statutory instrument. So please look at that Statutory Instruments Act and look at NoteUp. If you go to section 4, and I hope that I'm right with this, if you go to section 4 of the Act and go to NoteUp, you should be able to find a case, Bell against Townsend. See if you can find that. Does anyone, before we go on, I'm making an assumption here, but I better check. Be honest, you can be honest now, we're only in week 3. Do you know what I mean by NoteUp and can you use it? Yes, yes. NoteUp's great. It's a really good thing. Good. Okay. Well, we know what I'm talking about. When you're reading legislation, I use that regularly just to get a feel for how the legislation applies in practice. And it doesn't take long to get a feel for that. All right. So the Statutory Instruments Act and requirement to use note-up, become used to that. It's a very useful technique. All right. So dealing with the Acts Interpretation Act, Section 37A deals with the issue of age. Unless a contrary intention appears, the time at which a person attains a particular age, expressed in years, is the commencement of the relevant anniversary of the date of birth. Well, I guess that makes sense. Likewise, have a look at the following provisions in the Interpretation Acts, where relevant both in Commonwealth and state. Issues to do with number, distance, time, distinctions between the words may and shall, and you'll see some good commentary in your textbook there as well. So let's just take a simple example. In legislative provision, let's say it says it's an offence to discharge a bomb in a supermarket. Does that make sense? Does not. Does it cover if the person discharged more than one bomb and they attempted to use that as their defence? Yes. Great. So the Acts Interpretation Act will come to the rescue. What section of the Queensland Act would be relevant in those circumstances dealing with number? So as you're doing these sessions, always a good idea to have the Acts Interpretation Act handy, either in paper form or electronically. So what's the relevant section dealing with number in Queensland? We've got one answer in correct, although it came with a question mark, so it wasn't as definitive a response as we'd like to see, but it's correct. So what's the section in the Queensland Acts Interpretation Act dealing with that issue of number? Only one correct answer so far. Only one answer so far. If you're watching this as a recorded session, please go through this exercise. Part of what I'm trying to achieve is have you become familiar with it. It also indicates where you look. Do you look at Osley? Do you look at the paper? We've got a second answer, third answer. Megan got in second. Gareth just a tad behind. You're both correct. Now we're getting some good answers coming through. 32C. Okay, so the point of that little exercise is to, for the rest of this unit, have your Acts Interpretation Acts ready to go in whatever form works for you. And again, this is part of your toolkit. I'm not prescribing that you must do it this way or that way, but you'll develop a system that works for you and document that in your toolkit. Project Blue Sky is critically important, and you'll be reading all about that and making an assessment of it in your first assessment. All right, make sure that you're aware of commencement and issues to do with invalidity. There is some commentary in the textbook in that regard. Now, when I talk about invalidity, I'm really talking about this threshold jurisdictional issue. I mentioned that before legislation might be relevant to a factual situation, it must apply. It must have some application to the factual situation. But there's a broader issue, sometimes overlooked, and that is that possibly the legislation is invalid entirely because Parliament had no basis to make that legislation. I know it sounds bizarre, and we're all probably just trained consciously or subconsciously to accept that if the government produced something, it must be right, mustn't it? Not always. So as lawyers and interpretation, your job is to initially ask the question, does the Parliament have power to make this legislation? So I'm not suggesting that you do this every single time, and it might be just something that you keep in mind. So you don't necessarily have to use up one of your spots in the toolkit to say this, but bear in mind that the legislation must be within the power of Parliament to make. So at a Commonwealth level, where do we find the power of Commonwealth Parliament to make legislation? Can anyone give me a section number? I'll give you a hint, it's in the Australian Constitution. The section, oh, Megan was quick, or Tyler actually just beat you, Megan. Shona just a tad third. Very good, section 51. So you've got to look at that section 51. That's actually not entirely correct, because 51 provides for the overall powers, but there are some other exclusive powers, such as, for example, I think, have a look at 92. So there are some other sections as well, but 51 is the one that I always think of in terms of determining invalidity. So some things that you might want to consider in your toolkit: you'll need to consider the issue, the legislation, context and purpose, issues to do with ambiguity perhaps. So there are a whole range of things that you might want to consider. You might want to consider when the Act commences, consider issues to do with amendments perhaps, context and purpose I've mentioned earlier. You may have to consider intention and interpretive techniques. I mentioned earlier, intrinsic and extrinsic materials are things that you might want to consider also. And you may not have got all of that down. Sorry, I went through it fairly quickly. But what you would notice is that it was a lot more than 5. So you need to choose from that. I'll let you do this. When you're doing your toolkit and you've only got 5, you can break that down into subheadings. So you can make it 5 primary headings, make it 4 if you like, but don't go beyond 5. Then if you need to do what they do in the Queensland Handbook and have subheadings within those 5, that's fine. There's no problem with that. All right. So tonight we've dealt with some of the issues associated with the assessment regime. I've given you some homework. You know what that is. I'm encouraging you to share information and ask questions through the Q&A section on Moodle, to please respond to any questions that you see that you believe you can assist a colleague on there, and I will also continue to monitor the answers to the weekly problems, and after everyone's had a reasonable time to discuss the issue, I'll contribute some material as well. Are there any questions arising from the assessment regime or anything that we've covered tonight? All good? All right. Thank you very much for your patience. I know I've done a lot of talking, but I really appreciate your commitment to the unit, and keep at it. We'll see you next week. All the best. Bye then.